Just to start with an overview of today's presentation, we'll talk about the definition of asset protection, an overview of what you should and shouldn't do when protecting your assets. Before we talk about the specific topic, I always like to really lay the foundation. What is asset protection? Why do you need asset protection? And, why isn't insurance enough anymore? We'll talk about the definition of a LLC, or limited liability company. We'll talk about the advantages and disadvantages of the LLC. We'll talk about when you should use the LLC over other different types of business entities. We'll talk about the changes to the LLC, transfer of ownership, managers, name changes, things of that nature. We'll talk about dissolution of the LLC, both voluntary and non-voluntary. And we'll also talk a little bit about business succession planning. So to give you a little bit of information, what is asset protection? Well, to me, asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors while simultaneously still enjoying the benefit of those assets. And I know it's a long definition, so I'll repeat it. To me, asset protection is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats and creditors while simultaneously enjoying the benefit of those assets. So what we do as asset protection attorneys is we help our clients protect any asset they have from any financial threat. Our clients work hard for their money, and we want to make sure that they keep it. So a lot of people say, well, do I have enough assets to protect? And the short answer is yes. But actually, it's interesting. The less you have, the more you need protection. We represent a lot of business owners, doctors, CPAs, attorneys, financial advisors, people who receive the money in a divorce or an inheritance. And what I always tell them is that the less you have, the more you need protection. We represent a lot of professional athletes as well, and I always like to just give this example. Take one of my professional athlete clients who has signed for $50 million. Well, if they get sued for $5 million and lose, they're not going to be happy, but they still have $45 million left. Contrast that with the everyday person who's worked their whole life and maybe saved up a couple $100,000. Well, if that everyday person gets sued for $1 million, they're going to be wiped out. It's going to be extremely difficult, if not impossible, to come back from that. So the less you have, the more you need asset protection, but certainly not to the same degree. A lot of people say, well, what if I already have an asset protection plan? If you do, that's great, but number one, have it checked. A lot of people think they have an asset protection plan, but they might just have a domestic revocable living trust, which is definitely great for estate planning, but doesn't give you any asset protection benefits. So if you have an asset protection plan, that's great. I still suggest having it checked every year or two, just to make sure the laws haven't changed. You can get a couple different people's point of views, even if it's already set up. So a lot of people say, well, why do I need asset protection? And I always like this cartoon in the top right-hand corner of the screen. It's actually two lawyers, one saying, I say sue, and the other one saying, anyone in particular. And a lot of people laugh when I show this picture, but unfortunately it's not funny. Just like we're getting together today to hopefully benefit and learn from one another, the lawyers get together, and they're trying to figure out who are we going to sue next. Is it going to be the business owners, the doctors, the car dealers, the drug manufacturers, the financial advisors? So unfortunately, we live in a very litigious society. There's over 100 million lawsuits each year, and that number is only growing. If you think about it, in today's bad economy, so many people are losing their jobs. The people who are lucky enough to keep their jobs are making less and less each day. Why not go to any corner, hire an attorney on a contingency fee basis, which means they pay nothing. It only takes you maybe 20, 30 minutes of your time, and then if you win, you will probably win tax-free money. Lawsuits, unfortunately, are really becoming the next biggest business. There's a 1 in 4 chance you will be sued in the next year. So in the next 12 months, 1 in 4 people will be sued. The average individual and business is sued about 5 times over their lifetime. So if you're an individual and you have an LLC or a corporation, on average you're sued 5 times, and on average the company's sued 5 times. Now, I have clients that have never been sued. I have clients that get sued literally dozens of times a month. These are just the stats. There's a 50% chance of divorce, and a lawsuit can cost you tens of thousands of dollars even if you win the case. So, something to talk about here is somebody might sue you and it might be totally frivolous and have no merit, and they might lose the case. But if you've spent 3, 4, 5 years and tens of thousands of dollars at a minimum defending it, you're still a loser. So the trick here is not making the money, it's keeping the money. And everybody here who's ever made money knows it's a lot easier to make it than to keep it. The challenge that I give to all of my clients is that for every 60 minutes you spend making money, spend 60 seconds thinking about how to protect it. Well, a lot of people say, well, what about insurance? Isn't that enough? And I think insurance is great. I tell my clients buy as much as they possibly can because it's cheap and it helps you sleep at night. But with that being said, you need to understand that the insurance companies are a for-profit business. They're not here to pay all your claims. They're here to make a profit. In fact, if you drive down the highway, they're usually the only businesses that have their names on the huge, tall buildings. And that's because they're making a boatload of cash. 70% of lawsuits are not covered by insurance. So my father always used to say, the big print giveth, the small print taketh away. Well, anybody with an insurance policy knows there's usually about a half a page of what's covered and about 65 pages of what's not covered. Also, your coverage may be inadequate. You might have $100,000 coverage, but what if you get sued for $500,000? Who do you think has to come out of pocket the additional $400,000? Your insurance company might go bankrupt. Now, if I would have said this a long time ago, you would have kicked me out of the room and unplugged your phone. But in today's day and age, we have Fortune 500 companies and banks going out of business. So who's to say that the insurance companies won't be next? Also, insurance normally doesn't cover other uninsured financial risks and divorce. But actually, there's now a company online that offers divorce insurance, which is a pretty interesting topic. Again, insurance alone is not the answer. You need your own asset protection plan to supplement your insurance. So I tell my clients it's the belt and suspenders approach. You need as many layers and as many firewalls as possible to make it so difficult and expensive, if not impossible, for anybody to collect against you that they don't even want to sue you in the first place. The 3 maxims of asset protection. Number 1, protect yourself before you have a problem. If you want asset protection to work, you have to be proactive, okay? You can't buy car insurance after the accident. You can't buy health insurance after you get sick, and you certainly can't buy life insurance after you pass away. No difference with asset protection. You have to be proactive and make sure you protect yourself before you have a problem. Also, start with a very basic plan and add firewalls as needed. A lot of times someone will read one of my books and tell me how they want a personal international asset protection Swiss hybrid trust. And I have to spend 20, 30 minutes explaining to them why they don't need it. Start very basic, start very inexpensive. As your personal assets grow, your plan can grow. As your business assets grow, your plan can grow. As your education for asset protection grows, your plan can grow. But don't try and do everything at once. And probably most importantly is don't look for a magic bullet or one size fits all, one right plan. Don't do any cookie cutter work. Everything we do is individualized and customized and tailored. Everybody's personal and business assets are different. Everybody's personal and business threats and liabilities and creditors are different. So it might work for you, might not work for me, and vice versa. You need an individualized and customized, tailored plan that works for you, not somebody else. A lot of mistakes to avoid, but probably the 5 biggest one. Number 1 is hiding assets. Asset protection is not about hiding. It's not about secrecy. It's about protection. With a good asset protection plan, you should be able to tell everybody where your assets are and what you have. They just shouldn't be able to get to it. In fact, I tell all my clients, that they should just presume that at one point, if they're ever sued and they lose, they will probably have to give a deposition under oath or fill out a financial affidavit under oath and disclose what they have. So asset protection should not be about hiding or secrecy. Also, titling your assets to straws. I can't tell you how many times someone will come in my office and say, Mr. Presser, I'm being sued, but I gave everything to my brother or best friend. What actually makes you think that your brother or best friend has less legal problems than you? I've seen times before where the brother gets sued and loses the client's assets. I've seen times before where the best friend gets divorced and loses the client's assets. So you never want to go titling all your assets to straws. You also don't want to title all of your assets to your spouse, and we see this a lot with our doctor and physician and surgeon clients. They pretend that the spouse has no liability because they have quote unquote less liability. Well, nobody gets up in the morning and expects to be sued, and the wife or husband, whoever it may be, can just as easily get sued because they get in a car accident taking the kids to soccer practice. So you don't want to go titling assets, all of them, to your spouse. Also, they could be a divorce, and now everything's in his or her name. You never want to commit fraudulent transfers. This goes back to being proactive. The definition of a fraudulent transfer is when you transfer assets out of your name for less than fair market value, and as a result, the creditor doesn't get paid. And of course, you've done so while you have a present or potential creditor. Again, it's trying to do asset protection after the fact, which just doesn't work. And lastly, you never want to break any laws. Our law firm does both domestic and international asset protection. There's nothing wrong with having offshore accounts or offshore companies, but there's something very wrong with having them and not reporting them. So whether you're setting up domestic or international entities, you always need to make sure that you do all the proper reporting requirements with the IRS, the Treasury Department, etc. So why should you incorporate your business? Well, number one is personal asset protection. Probably the biggest reason why people incorporate, and when I say incorporate, I don't necessarily mean an S Corp or a C Corp. It could be an LLC or any business entity for that matter. What they're trying to do is they're trying to avoid personal liability from business debts. So by forming a company, you're ensuring that, God forbid, the business is sued, you're not going to get sued personally. You know, the law looks at you and your company as separate people. You have a Social Security number. Your company has a separate tax ID number. Another reason people form businesses is additional credibility. You know, if you just go out there and say, hey, I have John Smith's lawn mowing service, you know, a lot of people might look at you like, well, is he really reliable? But, you know, if you have, you know, the Best Lawn Mowers LLC or some sort of corporate name, it just gives you, you know, a touch of credibility. Name protection, it helps protect your name and preserves that for you. Gives you perpetual existence. So when you pass away, your company still lives on. So think about it. Walmart, you know, if the CEO of Walmart dies, well, Walmart still operates. Nothing changes. And also gives you an easier way to deduct expenses. Certainly, you know, we don't want to give you tax advice. You want to check with your CPA or accountant. But, you know, if you have a business, well, certainly you might be able to write off certain things. You know, if you're using your phone solely for the business, you might be able to write off the phone. You know, if you're driving somewhere, you might be able to write off the gas or the miles. You know, if you're taking a client to eat, you might be able to write off the meal. So certainly incorporating or forming some sort of business helps with the deductible expenses as well. So talking about the LLC, you know, what is the LLC? And essentially, the LLC, kind of like a corporation, it's totally separate and distinct from the owner. So the law looks at it as totally separate from yourself. That means that the LLC can obtain a separate tax ID number. They can open bank accounts, do business, everything under their own name. The primary advantage of an LLC is that its owners, they're referred to actually as members, have what's called limited liability, which means, you know, they can't be sued for actions on behalf of the company. The company could be sued, yes, but they can't be sued personally. So under most circumstances, and of course there's always the caveat, you know, they're not personally liable for the debts and liabilities of the LLC. So just to kind of give you an example, you know, if the LLC is ever forced into bankruptcy, then of course absent any special caveats or circumstances, the members will not be required to pay the LLC's debts with their own money. If the assets of the LLC are not enough to cover the debts and liabilities, well, the creditors generally cannot look at the members or the managers or, you know, officers for recovery. And there's a lot of good advantages to LLCs and also some disadvantages. And some of the good advantages are the tax flexibility. You know, you could choose to have it be a disregarded entity, which means it's almost like it doesn't exist and flows through right back to you for tax purposes. You can have it choose to have it taxed as a partnership, a 1065, et cetera, et cetera. So there's a lot of flexibility when it comes to how you want your LLC to be taxed. Also, they're very easy to set up. They're fast. They don't take a long time. There's not that much paperwork. Unlike, you know, comparing them to the S Corps or the C Corps, LLCs are very flexible. You know, you don't need as much paperwork. There's not as many rules and governances that will really watch over the LLC. Certainly you have to keep the formalities, and we'll talk about that, but not as bad as the S Corp or the C Corp. Probably one of the biggest advantages is the limited liability. So, you know, if you operate under your own name as a sole proprietorship or, you know, with a friend or business partner as a partnership, you know, you're personally liable. But the LLC, shields you, whether you're a member or a manager, from any liability of the company. And again, that's absent, certain and specific circumstances. With that being said, there's of course some disadvantages. Number one is, the tax flexibility can backfire. Unless you choose to be taxed like the corporations, LLCs are usually subject to self-employment taxes. So LLC taxes can actually be higher if you don't make the right tax election. It's always a great idea, obviously, to speak to a knowledgeable lawyer or accountant who can, get into this fully and give you all the, different choices regarding the LLC tax laws. And again, it might be different for someone who's in New York versus someone that's in Massachusetts. Also, the laws vary by state. The laws that govern corporations tend to be well developed, and the laws around LLC, they vary. I'll give you an example. In Florida, there was a Supreme Court case in June 2010, which essentially was called the Olmstead case, and it changed LLC law forever. So, LLC law is still evolving. It's still changing. LLCs have been around for a long time, 20, 30 plus years, but in law, that's not that new, or old, I'm sorry. Also, there's a lot of confusion sometimes about the roles. In a corporation, you have specific roles like, president, vice president, secretary, treasury. LLCs generally don't have these. They just have managers. Those are the ones who run the company. And members, they're the ones who own the company. So there could be some confusion about, who holds what role. LLCs compared to other entities, you use them for different purposes. LLCs are great, when you want to start a new business. LLCs are great if you want to hold real estate. LLCs might not be as good if you want to hold a checking, savings, stock, bond, or CD money market account. That might be good for a limited partnership. So again, there's no one size fits all. An LLC might not be the right choice for every single person. So you always need to investigate what all your options are and find out what the best fit is for you. Probably one of the biggest things that people don't realize is the importance of the operating agreement. And it is so important because a lot of times people will form the LLCs and they'll have no operating agreement, or they'll form the LLCs and they'll have some sort of canned operating agreement that they got online. The operating agreement, it really is an internal contract that talks about how the company is governed. So if you ever go to court, the courts are going to look at that internal agreement or operating agreement. It's almost like a contract. So it is so important that you spend the time or hire an attorney to make sure you put in all the asset protection clauses, all the anti-creditor clauses, everything that's going to be good for you, everything that's going to be bad for a potential creditor, because all the power and all the asset protection for the LLC really comes down to that operating agreement. So amendments, amendments just mean changes, and there's different types of amendments that you can make to the LLC. Number one, you can transfer ownership. Maybe at one point you own 50%, but you want to transfer or assign or sell part of your ownership. So certainly you can always make and do an amendment. You can change the manager. Maybe you're going to be the manager to start, but maybe eventually you're going to take on a partner who will act in a managerial role, or maybe you'll hire a real quote-unquote manager who's not an owner. And name change. You can change the name. And every year you fill out what's called an annual report, and I'm just going to go to the next slide where we talk about what the annual report is and things of that nature. The annual report is really just something that tells the state or jurisdiction that you're in every year that you still want to be considered as a business entity or LLC, that you want to remain in business. So if you didn't want to be have your LLC anymore, you can either dissolve it, which we'll talk about later, or simply not file your annual report, and then the state would close your LLC due to non-payment. But you don't usually file on an annual report name changes. That's usually an amendment. On an annual report, and again, it varies state by state, but typically you can include changes to members or managers, or changes to address. In regards to when they're filed, they're usually filed about once per year. You don't have to file it the year you created the LLC. So if you create an LLC today, your first annual report will be next year in 2014. And each state sets a different date on, when the annual report will be due. Sometimes it's on the anniversary. Sometimes it's just a certain day of the year and month. Annual reports are usually filed online, but again, varies by state. Some you could do by postal mail, some you can do by fax and things of that nature. And of course, again, if you don't file the annual report, well, then the state will close your business for non-payment, and that can certainly have a lot of negative consequences for the business owner. For example, in Massachusetts, just to give you an example, administrative dissolution can qualify as default on business loans and lines of credit, resulting in the lender, calling in the loan. Also, dissolution of the business means you'll have to go through a lengthy application process for reinstatement, which obviously also incurs a lot of payments and substantial fees. So you always want to make sure that, if your law firm is not handling the annual reports for you, that you are on top of it. Incorporating an existing entity out of state. So a lot of times people will maybe have an entity that maybe they filed in New Jersey and they move states and they want to say, hey, can we use this entity in Florida? And the short answer is yes. It's called a foreign entity, and you'll have to file and follow a lot of the same formalities as your domestic filing. Also, you'll have to do the annual reports. In this case, you're probably going to be paying double the money because you're going to have to file the annual report in the state where the entity was originally created, as well as the state where you're essentially, quote-unquote, moving it to. In regards to dissolution of the LLC, first of all, what is dissolution? Dissolution just means, closing up of the LLC. And there's two different ways you can do it. One is voluntary, and one is obviously a forced dissolution. In regards to voluntary, that might occur as a result of, the termination of the entity, duration, maybe internal disputes. The members can't agree on the operation, so dissolution may be the best option for the business before the business suffers further. Maybe the business isn't profitable. It's just not making as much money as you thought it would, so you dissolve the company. Maybe your mission's accomplished, so maybe the purpose of the business entity formation was satisfied and the business is no longer needed. Maybe other personal or business objectives achieved from the dissolution of the business, such as a new company, a new pursuit, things of that nature, and other cases provided by law or obviously by constitutional instrument. In regards to forced dissolution, that might occur based on a court decision, some other illegal activity of the business. Maybe the business is insolvent or interrupts the process connected with the debtor's assets, so maybe they just don't have enough money to go on. Bankruptcy, potentially, it just depends, but a lot of times it might be, if it's forced, somehow through lawsuits and court decisions. Piercing the corporate veil. So first of all, what is the corporate veil? The corporate veil is really just a made-up or imaginary line between the incorporator and the company that obviously should not be crossed. And, we talked back at the beginning of the presentation of why people form entities, and probably the number one reason is to protect their personal assets from business liability. Well, the corporate veil, if someone pierces the corporate veil, it allows the creditor to go after not just the entity itself, but after the individual as well. And, this applies to LLCs, corporations, limited partnerships, things of that nature. And in regards to when a court will really allow somebody, a creditor, to pierce the corporate veil, they look at a lot of different things. One thing they look at is whether or not the company is thinly or inadequately capitalized in the view of the type of business in which it is engaged. So, if someone starts a bank but they only have $50 in their account, certainly that doesn't seem like it's adequately capitalized. Commingling corporate and personal funds. Again, the business is supposed to be totally separate and apart from the owner. So if you start commingling personal and business funds, the courts might look at piercing the corporate veil as well. Obviously, fraud or improper purpose. If you use the company to, fraudulently induce people to do things that you legally shouldn't be and ethically shouldn't be doing, they might allow them to pierce the corporate veil. Maybe if you don't follow all the corporate formalities. And also whether the corporation is a sham or a mere facade concealing the true facts, or is merely just an alter ego of the shareholder. So again, you want to make sure that not only are you creating all these entities proactively, but that you're keeping them in good standing, that you're following the proper reports, and that you're following all the formalities as well. Some of the corporate formalities, and there could be a lot of them, might be holding annual meetings of the directors and shareholders or members, adopting company bylaws, keeping accurate and detailed records. Other times, they're called minutes of important decisions that are made at the meetings, and really just making sure that the officers and agents, abide by all the bylaws. There's also international LLCs, and essentially domestic LLCs are just LLCs that are created inside the United States, and international LLCs are LLCs that are created outside the United States. There's no black and white reason of when someone should consider a domestic LLC versus an international LLC. Certainly the bigger the business, the more you might want to consider an international LLC. But domestically, you can only get so much protection. When you go international, you can get a lot more asset protection, and that's because the entities may or may not be subject to the jurisdiction of the United States court system. So, we have clients who only have $100,000, and they create these international LLCs because they want to sleep at night, they want to be as protected as possible. We have other clients that, might be worth $500,000 or $1 million who don't create international LLCs, and they might just have a small business or no business. They might be older, retired, don't drive, don't own real estate, really just have as little liability as possible. But essentially what creating an international LLC does is it makes it so difficult and so expensive, for anybody to come after you because they'd have to go sue you in a different country where the laws are totally different that, very rarely does this ever happen. It might, and these things might be challenged 1% plus or minus or so with the times. And of course there's a lot of international entities aside from the LLC, just like there's a lot of domestic entities aside from the LLC. So domestically, there's the corporations, the S Corp, the C Corp, the LLCs, the limited partnerships, the trust, et cetera, et cetera. No different international. There's international asset protection trusts, international asset protection LLCs, and things of that nature. International LLCs work great for businesses. If you have a lot of cash that you keep in your business, if you have receivables that you keep in your business, an international LLC might be something that you want to speak more about. International Asset Protection Trust really comes about more when you're trying to protect post-tax dollars that are personally owned. So the international LLC is more for business liquid assets and things of that nature that are pre-tax, and the International Asset Protection Trust is more for post-tax or personal assets. Always like to just touch briefly, if you're going to do anything international, obviously domestic as well, just please make sure you're filling out all the proper reporting requirements with the IRS, the Treasury Department, et cetera, because there could be harsh civil and criminal penalties if you don't do that. Also, people should think about business succession planning. The definition is really just estate planning for business. So what is estate planning? Estate planning talks about where you want your assets to go when you pass away, and certainly you want that to happen quickly, privately, and the least amount of taxes that's legally and ethically possible. No difference with business succession planning or business estate planning. What happens if you die? What's going to happen to your business? You worked maybe 10, 20, 30, 40, 50 years on your business. You don't want it to just go away. What if you have partners? Well, you certainly, if one of them passes away, you don't want to be arguing with the spouse of the partner about what the value of the business is. So business succession planning really just talks about taking estate planning into play, certainly before something happens.